I'm Jeff Caesar, Director of Alinea, a UK customs brokerage. We file import and export documents on behalf of our clients that have in-house legal expertise addressing all aspects of UK customs compliance and practice. On the 1st of January 2022, a significant change will take place in the border operating model for Great Britain with the abolition of delayed declarations. Related to this is the removal of an easement on the obligation to declare a proof of origin. I will talk you through this change with fellow director and co-founder of Alinea, Holly Jade O'Leary.
This agreement, the UK-EU Trade and Cooperation Agreement, TCA, has a preferential zero tariff and zero quota rate for originating goods moving from the EU to the UK or UK to the EU. To benefit from the TCA, it is necessary to comply with the rules of origin. The rules of origin requirements are some of the most important provisions that your business needs to understand and meet under the UK's deal with the EU. The rules apply to businesses which want to import goods from the EU at zero tariffs or export goods to the EU so that their clients face zero tariffs.
Rules of origin are used to determine which preferential or other country-specific measures apply to imported goods. Their application, which relates to where the goods or the component parts are produced or manufactured, decide which country they count as originating from. In order to apply a preferential origin under a free trade agreement, the goods are usually imported directly from the originating country subject to the agreement. Goods can move through or be stored under customs control in countries that are not in the agreement so long as they are not entered into free circulation if they are to retain the preferential origin. Preferential origin cannot be claimed if the goods have been entered into free circulation in another country between leaving the single market and entering the UK. Non-preferential origin, however, remains unchanged as the goods pass through different customs territories unless the goods are significantly processed within one of the territories to obtain a new origin.
Regarding the preferential movement of goods between the EU and the UK, specific rules are detailed within the Trade and Cooperation Agreement and vary at product levels, so traders should consult the TCA to check whether their goods are compliant. There are a few overarching themes. Wholly originating goods automatically meet the requirements. This is where goods have been entirely created or produced in the EU or the UK. Where goods do not wholly originate in the UK or the EU, rules of origin are satisfied when there has either been substantial transformation of the product in the EU or UK, or a change in tariff classification at chapter, heading or subheading level according to the terms established in the TCA. Goods must be manufactured in the EU or the UK in accordance with the product-specific tolerance levels identified within the Harmonised System Classification 2017 within the TCA. Insufficient processing in the EU or UK on parts obtained from outside of the UK or EU may mean that they are not eligible for the preferential tariff. Note that both the EU and the UK will contribute to determine whether a good has enough parts to satisfy the rules of origin, subject to meeting the provisions on accumulation. Goods do not simply obtain EU or UK origin by being cleared through customs procedures into free circulation. They must meet the criteria identified within the TCA in order to qualify for preferential tariff treatments.
During 2021, importers have had up to 175 days to complete and submit their full customs or simplified import declarations. This includes the obligation to declare a proof of origin. For goods imported from or to the EU until 31st of December 2021, at the time of claiming preference, businesses have not needed to hold supplier's declarations. A supplier's declaration is a declaration either in the form set out in Annex 6 of the Trade and Cooperation Agreement or an equivalent document that has the same information describing the non-originating materials concerned in enough detail so that they can be identified. On the 1st of January 2022, where a supplier's declaration is needed, businesses must hold these at the time that they issue the statement on origin.
Under the Trade and Cooperation Agreement between the UK and the EU, a claim for preferential tariff can be made if the importer has one of the following proofs of origin. A statement on origin that the product is originating in the UK or EU as appropriate, made out by the exporter, or the importer's knowledge that the product is originating in the EU or the UK. A claim for preference and the presentation of the proof of origin is normally included on the customs declaration to enter the goods into free circulation. However, a claim can also be made after importation if it is made within 3 years of the importation date and accompanied by a valid proof of origin. In those circumstances, any duties would be repaid to the importer. In the UK, if the goods exported are worth over £5,500, the exporter must either apply and receive approved exporter status to indicate in the accompanying document, or provide their EORI number and a handwritten signature. Similarly, in the European Union, if the goods are valued at €6,000 or above, exporters who wish to accompany goods with a statement on origin must use the registered exporter system, known as REX.
A statement on origin is prescribed text which the importer adds to the invoice or any other document, including a commercial document, that describes the originating product in enough detail to allow it to be identified. The prescribed text of the statement on origin is shown in Annex 7 of the Trade and Cooperation Agreement. The statement or document may be in an electronic format. An exporter completing a statement on origin must hold information showing that the product is originating, including information on the originating status of the materials used in the production of the product. This may include a supplier's declaration in the forms set out in Annex 6 of the Trade and Cooperation Agreement or an equivalent document. A statement on origin may apply to either a single consignment or multiple shipments of identical products within any period specified in the statement on origin, but not more than 12 months from the date of the first import. If an exporter completes a statement on origin and later becomes aware that it holds incorrect information, they must let their customer know immediately in writing.
Importer's knowledge is an option under the Trade and Cooperation Agreement that allows the importer to claim preferential tariff treatment based upon their own knowledge of the originating status of the imported goods. This must be based upon a supporting evidence provided that the exporter demonstrates that the product meets the origin criteria identified in the Trade and Cooperation Agreement and is either wholly obtained, sufficiently processed, or meets product-specific rules of origin criteria. This may be in addition to other information, such as supporting documents or records, which the importer may already have. The information could include, for example, the harmonised system code of the product and origin criteria used, a brief description of the production process, or, if the origin criteria was based upon a specific production process, a specific description of that process, and also any additional information that will help verify the origin of the goods if HMRC asks for it. Before making an importer's knowledge claim, if the importer is unable to obtain supporting evidence as a result of the exporter deeming it to be confidential information, for example, the exporter may provide a statement on origin so that the importer may claim preferential tariff treatment. An importer making a claim for preferential tariff treatment must keep all records to show that the product is eligible for preference for 3 years from the date of importation. These records may be stored in an electronic format.
Under specific circumstances, a claim for preferential tariff treatment may be denied by either party's customs authority. A claim for preferential tariff treatment may be denied if the importer does not provide information when requested, or where a request for verification is sent to the exporting customs authority and a reply is not received within 10 months, or the verification report does not contain enough information to determine origin. Importer's knowledge may appear to be the most straightforward option, but it requires the importer to demonstrate supporting evidence to the satisfaction of the customs authorities in order to be noted on the customs declaration. Getting the exporter to provide a statement of origin is the low risk approach from the importer's perspective, unless the importer is certain that their knowledge is correct and is able to demonstrate to customs why this is the case. Rules of origin can be complex. Goods may enter free circulation in the EU, for example, from outside the EU, but then be exported from the EU to the UK, in which case they may not be entitled to the preferential tariff under the TCA, or they may be entitled, depending on what has happened to the goods, for example being used in the manufacture of other goods while in the EU. The Trade and Cooperation Agreement and HMRC provide statement on origin templates, suppliers declaration templates for products having preferential origin status, suppliers declaration templates for goods not having preferential origin status where duty will be levied on the excess product-specific tolerance levels, and long-term suppliers declaration templates. These can also be accessed by your customs agent, such as Alinea, in order to support a claim for preferential tariffs. Alinea provides a full consultancy service on all matters relating to customs law and practice, including rules of origin. Please contact us for further information or advice.